glorious, glorious spring evening. What a beautiful day it turned out to be. May 10th, Sudden Valley Community Association Board of Directors meeting. Meeting is called to order, and roll call. David Narsico will be attending by phone. I've got him dialed up. Odell and Vanessa have told me that they have family situations and they will not be here. Otherwise, I believe we're all here, and we do have a quorum. So first up, adoption of agenda. Are there any changes? Okay, I see none. Therefore, unless there's an objection, the agenda is adopted by acclamation. Now, the first thing, as I mentioned last board meeting, we'll have a presentation by our association council. He came on board in 2012, and I will say he's the guy that won the Casey lawsuit, so he knows how to read statutes. Rich Davis, and he will discuss the impact, as at least in his first round of analysis, of the Senate Bill 6175. Rich, take it away.
Okay.
Oh, by the way, I should mention, Rich will give his talk, and then the board will have 15 minutes to ask any follow-up questions. It'll be board only. We did send him a list of questions that everybody sent in, so he's prepared to address those tonight.
Okay, so I'm here to talk about the new statute. It's commonly known right now as Senate Bill 6175. You can go ahead, Lisa, and advance the slide. And this act is going to be officially known as the Washington Uniform Common Interest Ownership Act, or WCOIA for short, and I'm going to say WCOIA tonight. And we'll get it going here in a second.
Sorry, I don't know why I'm seeing it on my screen. I don't know why it's not coming up there. Apologize for that.
I'll go ahead and carry on, and then hopefully the slides catch up here, just in the interest of time. So just to make a long story short, the effect of WCOIA is essentially, the main effect for Sudden Valley is that we have a bylaw right now that requires a 60% majority in order to increase your assessments. And that's going to go away. WCOIA supersedes that. And this act takes effect on July 1, 2018. So no longer will 60% be required. Instead, the budget process and the assessment approval process are going to be aligned. In other words, there's going to be a single vote to approve both the budget and the assessments that are set forth in the budget. Go ahead. I'll talk about that in more detail, but let me just briefly mention how we got to where we are. All right, so there was a drafting committee. This has been in the works for a number of years. There was a drafting committee, essentially of community association lawyers, that were tasked with taking what is known as the Uniform Common Interest Ownership Act, which has been around since 1982. And there are a lot of uniform acts in the legal community, and this was one of them that dealt with community associations. And what it intended to do was to consolidate the laws that govern different kinds of common interest communities all into one. So for instance, here in Washington, if you're a community association lawyer, you are required to be familiar with 5 different acts: the Homeowners Association Act, the Horizontal Property Regimes Act, which is an act that applies to condominiums that were created before 1990. The Washington Condominium Act applies to condominiums created after that date. The Washington Nonprofit Corporation Act, and the Washington Mutual and Miscellaneous Corporation Act, because some associations are incorporated under either the nonprofit or the Mutual and Miscellaneous Corporation Act. So the intent of WCOIA was to make it easier for a community association lawyer, in a sense, to only have to, and for community associations to only have to refer to one law. You'd have a single point to go to find out what laws governed. Unfortunately, the legislature didn't take the drafting committee's recommendations, unfortunately or fortunately, I don't know, depending on your point of view, but what they ended up doing is, because the drafting committee had recommended that community associations created after the effective date of July 1 would automatically be in the, all community associations, whether or not you were created before or after July 1 of 2018, you'd be governed by WCOYA. That way we'd get rid of all of these other laws. They would not be relevant. Instead, what the legislature did is it allowed for an opt-in. So essentially, you can elect to be covered by WCOYA even if your association has been around prior to July 1, 2018. So let me just talk briefly about who it applies to. It applies to any HOA, homeowners association, or a condominium that's created after July 1, 2018. It will apply in its entirety to any association which elects to opt in. And just for reference, for anybody who hasn't looked it up yet, I mean, it's a healthy law. Here's a notebook. It just contains the law itself. This has not yet been codified, by the way, into an RCW, so I don't know how to refer to it. Most of these community associations are under RCW 64 or something, but the code revisor has not yet got around to that. In terms of Sudden Valley and homeowners associations, Section 326 of WCOYA is going to apply to Sudden Valley and all other homeowners associations regardless of when they were created. And it's going to start taking effect on July 1, 2018. And that's the budget and assessment process we'll talk about in a moment. So just briefly, can Sudden Valley, if it wished, could it be covered, elect to opt in to be governed by this comprehensive act? It could. There's a process to do that, which requires a kind of a recommendation by the board and ultimately approval by the membership. In the Sudden Valley's case, however, you've got a separate set of covenants, CC&Rs, that govern each division. So it would be a very unwieldy process, and essentially every division would have to opt in for it to be effective. So probably it does not make sense for Sudden Valley to go down that path. All right, next slide. So the real meat of this that you're going to be concerned about is Section 326. What Section 326 does is it overrides any conflicting provisions in the homeowners association statute. So the big issue in the Casey litigation that we had a few years back was RCW 6438025, which talked about a budget adoption process. We have a new budgetary adoption process in Section 326, and that's going to supersede what's in 6438. So this is what we are governed by now. In addition, it supersedes the governing documents of any homeowners association in order to protect the public interest. There's some interesting language in Section 326, which again is just budgets and assessments. And it says in order to protect the public interest. And you might ask yourself, well, what public interest is there? Why was that language added? And I'll talk in a few moments about impairment of contracts, but I think that language was probably added to prevent an impairment of contract argument being made. And that will be, perhaps determined in courts if this matter ends up being litigated in the future, but that language in that particular sentence is meant to address the Casey decision and to overturn that. So, and the legislature, this is something the legislature does from time to time. If there's a court decision that is rendered, which the legislature disagrees about, that they feel that the court's misconstrued the interpretation of a statute, they'll come back and amend the statute to clarify, say this was really our intent. Next slide. So the budget and assessment process that is set forth in WCOYA is very similar. There's not a big change to the process that you go through now. You have to adopt a budget. I mean, you being the board, you present that to the membership for ratification at the annual general meeting. And again, unless a majority of the votes in the entire association reject that budget, then it's ratified. If you don't have a quorum at the meeting, it doesn't matter. You've got a meeting to ratify the budget, And unless 50% of all the owners in Sudden Valley reject it, it is ratified, whether or not you had a quorum at the meeting. The major change, though, so that's all similar to what we have now, no change. But what's a major change is that in that vote, the budget and the assessments that are set forth in the budget are ratified unless there's 50% or more of the owners in the association who vote against it. Okay, another couple of changes is you all get what's called a summary of budget each year. All the members get a summary of budget, and it's required to have certain information in it, and go to RCW 6438 to find out what's there. Wacoya requires some different information to be included. And so there's a list, I've included the entire list here. Your projected income that you receive by category, your projected common expenses and those specially allocated expenses that are subject to being budgeted, both by category. And the important one here is the amount of the assessments per unit and the date the assessments are due. Now, the term unit is probably a little bit unfamiliar to you. Wacoya uses that to basically refer to a separate parcel of property, so a lot that is assessed. Here at Sun Valley, whether it's a vacant lot or a developed lot, it would be a lot. And then it requires you to include the current amount of regular assessments budgeted for contribution to the reserve account. And next slide. And a statement as to whether the association has a reserve account that meets the requirements of another section of Wacoya, which is similar to the reserve account requirements in the 6438. And if so, the extent to which the budget meets those reserve study projections or deviates from the recommendations. And then finally, the current deficiency or surplus in reserve funding expressed on a per unit basis. So Wacoya does not mandate that you have a reserve account set aside or mandate any particular funding of reserve accounts. It just says you have to provide this information to the members in the budget each year. All right. The last thing that it does, and this is applicable to Sudden Valley, is it speaks to special assessments. One of the interesting things about the Homeowners Association Act is it doesn't say anything about how special assessments are to be passed. And Wacoya says, well, you pass a special assessment much like a budget, much like you pass the assessments each year. The process is the same. The board proposes the special assessment. It's the same process as for ratifying the budget. Wacoya also says that the board can provide for special assessments to be due and payable in installments over any period that the board determines is reasonable, and also can offer early payment discounts if a member desires to pay those special assessments off early. All right, next slide. So the bottom line is that under this law effective July 1, that Casey decision will no longer be controlling on Sudden Valley or any other homeowners association in the state. And Article 3, Section 19A, I'm sorry, I've got a typo there, 19A of the bylaws is superseded, which means that increases in assessments will no longer require 60% approval of the membership as Sudden Valley's operated on for many, many years. So this will be effective in the fall of 2018 at the AGM. All right, next slide. Now, the question that comes up, obviously, is, well, can the legislature do this? Can the legislature really dig into individual association bylaws and override them? Right? That's the $64 question here. Well, a potential argument is this. Article 1, Section 23 of the Constitution says that the legislature may pass no law impairing the obligation of contracts. Well, we all know from our litigation in the Casey matter that bylaws are deemed to be a contract. And the argument would proceed to say that this legislation overrides those bylaws, therefore overrides Sudden Valley's contract. So that's an impairment in violation of the Washington Constitution. Having said that, you need to know that impairment is not as bright line as that argument might make it sound. And you'll see instances, even in the Homeowners Association Act, where the legislature, in a sense, impaired bylaws and contracts that already existed. For instance, there's provisions in there that say you can't have rules restricting the display of flags, of the United States flag, or political yard signs, except there's some limited restrictions that you can impose. But so the legislature has already done this, even in the Homeowners Association Act. Okay, next slide. So my view of this is that this legislation, the individuals that drafted this, drafted it in such a way as to prevent a court from reaching the conclusion that there's an impairment of contract. And why I think that is, if you look at the judicial test, in other words, the test that a court will go through to determine if the Constitution was violated, it's a three-part test. It asks, number one, does a contractual relationship exist? Well, clearly it does. We've got bylaws. Number two, does that legislation substantially impair the contractual relationship? An argument could certainly be made that it does because it supersedes and makes void Article 3, Section 19A of the bylaws. But then the third part is kind of the key question, and that is if there is a substantial impairment, is it reasonable and necessary to serve a legitimate public purpose? And again, if you were wondering why that language was in Section 326 about protecting the public interest, my guess is that that was put there to address that issue. Again, though, this is new legislation, hasn't even taken effect yet. There may be litigation, there may be several court cases that are filed over this very issue or other aspects of Wacoya, and how a judge might rule, and the Court of Appeals can't be predicted with any certainty. But my view is that it's going to be an uphill battle in this case to prove an impairment because of the language that's in the contract, that's in the statute, and the findings of the legislature that this was necessary to protect the public interest. So then the question is, well, why is this different than Casey? How is this case different than what was in the previous litigation? Well, in Casey, what we argued was that the legislature, because the plaintiffs, let me just back up. The plaintiffs said the statute, RCW 6438, takes priority over our bylaws. And we argued, no, it doesn't, because the legislature did not intend to abrogate bylaws of associations. Why? Because it wasn't explicit at all. I mean, it was a very subtle argument. You had to dig through, you had to be a lawyer, essentially, to make that argument. It wasn't clear on its face. Here, Wacoya is very explicit. There was no doubt, if you read the language of the act, that the legislature intended for Section 326 to supersede any conflicting bylaw provisions. So I think it's exactly the opposite situation that we faced in the Casey litigation. But again, there may be cases that are filed, and we'll just have to see how that plays out. All right, next slide. That's all I have. I can anticipate a question, but I'll go ahead and I'll let questions be raised here, answer those, and then if it's not asked, I'll address it at the end. So I'll open it up to the floor.
Okay, so as he said, if we don't ask questions at the moment, he's received the list, and he'll go over questions that are already on the list, which I believe I shared at least with the executive committee. I can't recall if I sent it to the whole board. In any event, so why don't we just go down the table, and if you have a question, please state it. And these are questions, not arguments.
Now, do we have a time limit on this?
Yeah, as I repeated earlier, we got 15 minutes to go through questions.
Could we have Rich, I ask questions and send them in to the board?
Okay,
And
hold
I
on.
wouldn't,
Right. David on the phone was asking that people speak into the microphone so he could hear. And
Very clear, Larry.
yeah, because my phone is close to me. But Linda, you need to use your microphone.
I guess the question I had for Rich is, could he answer the questions first? I asked some, and I don't want to ask them again if he's going to answer the ones that were sent to him. That's my suggestion.
I didn't bring those with me. If somebody has those, I'm happy to answer them.
Oh, let's see. Do you have your phone? Because I know the execs at least got a copy of that list. I can't use my phone because David's on it. One of the major questions he already addressed, which was, can the legislature overrule bylaws? And the clear answer is yes. It has done so many times, so that's already answered.
Can I ask one?
Yeah, sure, while
I
we're
don't-
looking for the list.
This was one that I don't think I posed to you, but it's just a general question about the rest of the Senate bill. And I don't know that you've reviewed it in quite the detail that you did 326 and 110, but I'm curious whether you found any wide variances in our practices and bylaws versus what else is in Senate Bill 6175.
There are some changes, and I think that there are some changes that could be beneficial. I'll give you one example that I think is hugely beneficial. Right now, the Homeowners Association Act and Condo Act do not really define what an association record is. So we get requests from time to time, and there's controversy about whether emails, for instance, are association records. Well, Wacoya clears that up and says that they're not. It doesn't come right out and say it, but it says what is an association record, defines it, defines a process for making requests of association records. So it gives more definition. Well, I think we might have, I proposed a policy at one point. I don't know if we actually adopted that policy, but we tried to do the very thing that Wacoya has done. So that's one example. There are other examples where I think that, that it provides some benefit and clears up ambiguities. Thank you.
Let me do a quick follow-up on that.
Okay.
Is it possible to adopt a few, pick and choose from Wacoya and say, hey, we like this section, can we amend our bylaws and adopt that?
Unfortunately, there's not at this point. Now, this act could be amended in the future, and that option might be offered. Currently, it's not. It's all or nothing.
Okay, if that proposal does not violate the prior RCWs, is it still not possible to incorporate it into our governing documents?
You could incorporate provisions of Wacoya into your governing documents, for instance, your bylaws, amend your bylaws and incorporate some language that's similar to Wacoya, of
Okay.
course. Yes.
Okay. Oh,
Yeah.
very good.
And it wouldn't violate, as long as it didn't violate the Homeowners Association Act. Because
Exactly.
that governs.
Okay.
Okay, one of the questions is, can the state legislature, without agreement by Sun Valley members, amend any part of the governing documents that part of each member's contract? Okay, I've addressed that with the impairment argument. Actually, I've addressed these first three. The next question is there another bill under consideration that may repeal this new statute? Not that I'm aware of. I think that it's far too soon for the legislature to even think about amending it, because what happens is the legislature will pass a bill, you'll see what the effect of that is, they'll get feedback on how the bill is operating in practice, and then lobbyists will start lobbying the legislature, and ultimately maybe some changes get made. But it's much too early for that to happen.
Can I inject something there? Would the legislative session be a factor in timing of that? If there were something, since the calendar starts in January and goes for 2 months on non-budget years?
Yeah, so, right, the action to amend Wacoya would have to take place during a legislative session. So you're going to have, 6 months, really, to see how it plays out in 2018. It's unlikely anything's going to happen next legislative session, I would think. How likely is this to be subject to court repeal after litigation? Well, I've walked through that analysis. I don't know of any other basis that it could be challenged as I stand here. Give a creative lawyer time, they may come up with some other arguments. I talked about the one that I thought was most obvious. Next question is Sudden Valley implements this, will Sudden Valley lose a lawsuit for doing so? It's kind of an unclear question to me. I'm not sure what the thrust of that was.
Could Sudden Valley be challenged for doing what the law says that we're supposed to do?
Oh, yeah, somebody could, of course, and they could argue that, let's suppose, for instance, that in November, you do as I recommend, and you have one measure that goes before the membership to approve the budget and the assessments. you could get challenged. Somebody could file a lawsuit against Sudden Valley, and they would say, you violated our bylaws. And your response would be, well, we're following the law, and they would say, well, but the law violates the Constitution, so you really should be following the bylaws. That lawsuit could certainly be brought. Again, my view of it at this point is I think it's an uphill battle. And moreover, I should say that the law is presumed to be valid until proven otherwise. So as a board, you're obligated to follow the law. Even if you think downstream maybe a court would overturn it, again, the law is presumed to be valid when the legislature passes it. Next question is, what if Sudden Valley chooses not to implement the law? In other words, what if you continue to follow your bylaws? I think then you could be sued for that as well, for not following the law, because the law takes priority. Every year we go through this retreat, and we talk about the priority, and the law trumps anything that's in your governing documents. So, will dues immediately increase on July 1? No, because as I've talked about, the dues depends on what the board does in terms of a budget for next year, but whatever dues are established in that budget, assuming it passes, then it will take effect on July 1. Does this impact Sudden Valley's voting methods, procedures, or timeline? No, other than what I've said above. It affects it impacts the effect of the vote, but essentially the process remains the same for approving a budget. Next question is, can Sudden Valley's governing documents be changed to limit the size of future dues increases or decreases? I think it probably could be. So if the membership passed an amendment to their governing documents, probably the bylaws, I would think, and got the requisite number of members to approve that, I think that it probably could. Again, that would be tested in court too, I'm sure, but I don't see anything in Wacoya that would lead me to believe that the association couldn't say, well, we're going to limit annual increases to a certain percent. Does some other existing RCW limit the size of HOA dues increases? No. Can Sudden Valley's governing documents be changed to require minimum funding and regular predictable increases? I think probably some amendment could be done, such as that. I don't think Wacoya changes anything in the law as to that matter. Can a board be sued for a dramatic, demonstrably unwise decrease? Well, the board, you probably heard me say before, lawsuits are brought all the time. Some are frivolous, some have merit. Yeah, sure, a board could be sued. Even if it's unwise, though, there is this thing called the business judgment rule. If your decision was reasonable under the circumstances and you took the time and effort to investigate the decision that you made, you're probably immune from a lawsuit, a successful lawsuit. Does this have any impact on the ability of Sudden Valley to allocate assessments based on home value? That's a concept that has been discussed before, and I don't see anything in Wacoya that would prevent that concept from continuing to be explored and implemented if that's the will of the membership. Does this change how bylaw amendments are made, such as the need for member approval or when amendments go into effect? No, it doesn't say anything about that. Does this allow the board to delete voided terms in any governing document without member vote? It does not. So here's the interesting thing is you'll still have Article 3, Section 19A in the bylaws. My recommendation would be to bring a vote to the membership to have that taken out so that it's clear that, because anybody who's buying into Sudden Valley and doesn't know the history here may not look at the law. They would be looking at the bylaws, which is one of the points I made during the Casey litigation. Is people, sometimes read these things, and this is what they normally read, not the statutes. So you may want to consider bringing a motion to the membership. But if you did that, keep in mind that if this impairment argument is brought at some point and is successful, then which means whatever's in your bylaws at that time would control. So the board has to consider that possibility. The fact that that language is in your bylaws as of July 1, 2018, just means it's meaningless. It has no effect because the law has trumped it. So it'll just sit there without any effect. Finally, does this immediately provide Sudden Valley any means to deal with rogue boards or problematic directors? No, it does not. It doesn't. Section 326 doesn't talk about that, nor does Wacoya in general talk about that. There are remedies to deal with a board that the membership is unhappy with. There's recall powers. There's voting members out off the board at the next election. There's also lawsuits if the board were to violate their duties, their fiduciary duties, but Wacoya doesn't add anything to that. That's all the questions.
Okay, so that was the list. So we'll go around, and again, I'll start. Linda, do you have anything else?
Larry, just before you start, though, we're going to keep everything to 15 minutes, no longer?
Including this? or-
We've been eating into that 15 minutes.
5 minutes.
Okay.
So we have 5 minutes left.
Okay, yes.
Thank you.
Simply because when at least I submitted a question, didn't see it answered, but on our deeds, there's an attachment to each deed that was anybody entered into in this association. And part of that deed is that our covenants, conditions, and restrictions and easements are from Sudden Valley, apply to us. If you don't amend your bylaws, future people that are going to buy into here are then going to think that's what takes place, and they're going to say, that isn't what my bylaws
Linda,
say.
we've got 5 minutes.
I know, I'm just
And
saying,
he's already addressed that.
but
he's-
not really.
Yes, he did. He just said he's recommending that we change our bylaws, and that's a decision that we'll have to make and that the community will
That
have to
works
decide.
for me, that works for me.
Yeah, he just said that.
Then I have another question. So if the law of impairment is involved and Sudden Valley in November votes according to state law, how can that negatively affect us if it's overturned and found that it does impair contracts?
That's a very interesting question. I don't know that I have an answer for that. It could be on a prospective basis. In other words, the decision would be prospective. So I don't know that the court would actually invalidate anything that you had done up until that date, because the effect of that could be very significant. For an association that acted in reliance on, let's say that a dues increase is proposed this fall, you take that money in, you spend it. Year or two later, Court of Appeals or Supreme Court says, no, the legislature didn't have the right to do that. Can you imagine the hardship that associations would be under then to have to pay back that money? I just don't see the courts as really undoing what has already been done. But I think if a decision is reached by a higher court that this legislation is unconstitutional, then as of that date, it would be unconstitutional, and you would go back to whatever is in your bylaws.
At that time.
At that time.
Which means that if we've changed it in the meantime, then the change is what's in effect.
That's what would then be in effect, right?
Right. Okay,
That works for me.
thanks. Rich? Sarah?
Okay, I have two quick questions. The first one is there anything under Wacoya that offers protection for unreasonable or large increases?
No.
Okay. And then what is the process for, you said that 326 applies automatically, but that it's a choice to, or a decision to be included in the rest or not. What's the process for that? Is it a board vote or?
Both. The board, first of all, recommends opting in to Wacoya, and then it goes to a vote of the entire membership. And 30% of the entire votes in the association have to participate in that vote. And of that,
67.
67%.
No, he's saying
No,
the
it's-
minimum number of votes that must be cast.
what did I just say the other day? Just gave you that number, now I forgot it. It's a fairly low threshold. I think it's a simple majority, but you have to have at least 30% of the members in the association voting.
Skip
Yeah.
the 50%.
Is it two-thirds?
Eric.
Two-thirds,
Eric.
okay.
30% must vote, and then it's a two-thirds.
Two-thirds, okay.
Eric, you're up.
I have no
Larry, you're up.
I've got mine.
Leslie?
Okay.
Okay, then, David, do you have any additional questions?
Well, there's a lot of things I was unable to hear. Let me ask this one. Is it legal to do a bylaws request for a limit of 7% change to the budget? Number one. And number two, the variable dues based on assessed property values. Both of those would go towards the budget. The assumption is that the budget would pass. And again, if we had a ballot measure that says that budget that we propose to the community is limited to plus or minus 7%, it can either rise or drop below that from year to year. And again, number two, the variable dues based on assessed property values, that deals with the formula, not the dues itself. So if the budget passes, if we had something like the variable dues based on assessed property value, then that formula would be used to ensure that the budget was achieved, but in accordance with these two particular items that we would propose to the membership. And again, if they pass, then those would be guidelines or limitations, or however you want to define it.
Yes, David, I'm sorry you were not able to hear him, but Rich did clearly say that the answer to both of those is yes. There can be a cap or a floor or any other kind of limitation put into the bylaws, and there can be a change in what the board does with regard to allocating dues amongst members, although that is, maybe you would like Rich to say a couple of words about the standards that we have to apply for creating differing dues.
Right. That issue is governed by your governing documents. There's really two, and there was a case called Ackerman versus Sudden Valley that dealt with this, and what the court held was there were really two criteria. Whatever, not a scheme, but whatever structure you have for imposing assessments, it can't create it can't create two tiers of dues, which means that one type of membership, it has more favorable attributes than another. That's number one. And the second is that the assessments have to be equitable in nature. And I know that's, kind of a loose word.
That gives it a single formula instead of now we have two formulas, and the laws are such that the dues must be equitable but not necessarily equal.
He's saying yes to that. That is quite correct. Mm-hmm. He is saying you are correct.
That's right.
Okay, so that doesn't necessarily say that all the dues are different. It's again a single formula applied to all residents.
That's correct.
All properties.
Yeah.
Okay, thank you.
Yes. Okay, so that's 15 minutes. Thank you.
Okay, you're
very
welcome.
much for your time, and we appreciate your analysis. And I presume that you'll just send to bod@suddenvalley.com a copy of your slides.
Okay.
Super.
All right.
Thanks so much.
Thank you.
Okay, so now we'll go into property owner comments and board comments. And thank you all for waiting until we got through our presentation. Again, the normal process is when you're recognized by the chair, come up to the podium, name and address or lot number, division, et cetera, and then you've got 3 minutes. So are there any homeowner comments at this time? You see one there, yes. Nope. No, that's not a microphone. That's a, yeah. That's our new camera.
Foremost, thank you for straightening me out. Is this on?
Yeah, it
Any
is.
feedback? Okay, thank you. Chuck Luttrell, Division 32, Lot 49. First meeting since the last vote count. And what I'd like to say to the board members and to the GM is thank you for the work you've done over the last 3 to 5 years. I've been here over 15 years and watched the degradation of our infrastructure that whole time. And it's been a brutal fight. And some of you members have put hundreds of hours in, Some of you have put thousands of hours in. And it's so exciting for me, and the future looks so bright that we bottomed out that curve and we're coming up in repairs. I mean, I just can't tell you how exciting it is to see happiness. You know, I'm talking to my neighbors. I saw the on TV the vote, when the votes came in, the announcement, the joy in the neighborhood. And I know many of you worked very hard creating the foundation for where our infrastructure was. I think, Mitch, you ended up doing a ton of that workload with your team, getting things figured out, what we needed to do, and where we really were, because that had never been done in the prior times that I've been here. So thank you very much for that. And again, for those of you that put the hundreds and thousands of hours in, Mr. President, your board, the previous boards, a couple, 3 boards prior, but I've noticed it's been mainly in the last 3 to 5 years that the wheels have really churned and gotten some things done. And Mitch, I know you and your gang had to do a ton of research. I want to thank you for that extra effort and let you know the people I talk with and run into in the neighborhood every day really do appreciate your work, the committees that did work, and the previous boards that have done really a fantastic job. Thank you.
Thank you, sir. Are there any other homeowner comments? Okay, are there any board comments?
Yes.
David?
David here. Yes, just a little feedback on this process. You are the only one that comes through loud and clear at my end, Larry. Most of the others are garbled or can't hear, or whatever the case is. But you, the way you're handling your microphone, you're loud and clear. This is for future, board members who are doing this. I don't know how I'm coming through at your end, but you personally have come through very clear at mine.
Well,
Again,
again,
nobody else
Dave,
did.
we'll just have to come up with a better way to do teleconferencing. Again, just to explain, you're just on my phone. It happens to be sitting close to me, so you hear me well. Okay, are there any other board comments? Yes.
Just to let you know that the Emergency Preparedness Committee is having their annual safety fair on May 19th in the Dance Barn. We have 42 vendors slated to come from 10 to 2 o'clock. That's the 19th, right here, from 10 till 2 p.m. Thank you.
Okay. That appears to be the beginning of the announcements section. We're done with board member comments. So moving on to announcements, I saw a hand over there.
Eric, if you could do Community Day, because you're right, I followed Mike, you're doing announcements, and Summer's daughter is back in the hospital, so she won't be here. So Eric, if you could do Community Day, I appreciate it.
Sure. Community Day is happening this Saturday from 10 until 2, I believe, right here at the Dance Barn. And this is a day that's being sponsored by the same group that brought the Sudden Valley Strong the initiative to its fulfillment. And they're going to have everything from bouncy house to putt-putt golf to a lot of activities for families and kids to be in this recreational area. So please come and enjoy.
Thank you. Any other announcements?
I have one.
Okay.
Next Tuesday, is it next Tuesday evening? The county is going to be here? The county council? Yes, there's going to be a presentation from the county council here in the Dance Barn next Tuesday evening at 7 o'clock for 2 hours. And I am not sure the scope of their presentation or their meeting, but there's going to be, I'm sure, opportunity to meet people, and I'm going to ask if they would like to have it streamed, but they haven't agreed to that yet. So,
Mitch, would you describe a little more about that? Because it was something that kind of hit me by surprise as well.
I will. I'm going to do this from memory. This has to do, I believe, with the county jail. Is that correct? Mm-hmm. So the county outreach through the supervisors wanted a team from county council to rotate through the county to to talk about the issues that they have encountered, why they want a new jail, the issues that they're addressing with the current jail, and what their plans, issues, concerns, and options are. And I believe that is the subject of this outreach group of people from the county council.
Okay, so if y'all are interested in the jail, which is an issue that has come up, and I am suspecting it's likely to come up again, then Tuesday is your opportunity to hear and perhaps ask them questions, although communication has been very lacking on this issue, so I'm not certain of the format.
Well, what I know is that they are going to have a table with the council members, and then there will also be a podium with a microphone for questions, is what I understand.
Super. That's why he's in charge of communications.
I have another one for you. An announcement. It's a bit of a shocker. I think it'll be more of interest to most of the board members. Pat Sorensen resigned today. He is leaving, and he's going to a different area, and so so he is in charge of the water district, and so he is moving on.
Yeah, that is definitely a surprise.
It did come out of the blue.
Okay. Any other announcements? All right, then, from an announcement from the community? Yeah, sure. Name and everything else.
Yes, my name is Ken Murray, 30 Creekside Lane, and I'm the president of New Hope Therapeutic Society, which runs Ken's Cozy Kitchen. The announcement I would like to add to the Saturday festival, we're having the day after tomorrow. Come hungry, because Strong has asked me to have a special menu out for the community. You're going to have a burger, you're going to have a drink, and for the total cost of $5, tax included, or a brat, or a hot dog. The brats are going to be $4, and the hot dog is going to be $3, and it'll come with chips. So come hungry.
Thank you, sir. Okay, there is nothing listed under continuing business, so we'll move on to new business. There's an Architectural Control Committee.
Yeah, I have a request that the board approve Rob Gibbs to fill our vacancy. He's been vetted by the committee and voted unanimously to be accepted, so I'm just asking for your approval.
Yeah, people didn't hear you.
Microphone there.
Rob Gibbs has been suggested, recommended by ACC to fill their vacant position.
Correct.
And he's vetted and cleared, and so I would suggest, unless there's any objection, that we adopt that by acclamation. No objection. Mr. Gibbs is on.
Point of order, since he's in the room, you might identify him.
Well, it's not really a point of order, but Rob, if you don't have any problem. Thank you, Rob. Okay, Parks and Trails Committee, reorg.
The Parks and Trails Committee has asked that I present to the board the proposal to approve adding recreation under their umbrella of activities, and they will change the charter to so reflect that, so that all the activities that are going on between the different things in the rec center and Parks and Trails and so forth are all under one. They can work together with better, I guess...
Coordination.
Coordination, yeah, there's the word.
Okay,
So
is there a recommendation?
I
Is there
shall
a
make
motion?
that motion, actually,
I would
if that would be
presume so.
accepted.
I second it.
All right.
Okay, so that's the motion, and it's been seconded. Would you like to restate that so we clearly have
To
that?
add recreation under the charter or under the responsibilities of Parks and Trails, and they will rename it to Parks, Trails, and Recreation.
Okay, the motion's been made and seconded. Is there any discussion Do you have anything further to add, since you made the motion?
No, only that they had I will say that they had a meeting with all of those individuals present, and I believe that it was unanimously recommended by the committee, as well as all of the outstanding people who were there from parts of recreation. So I think they're all in favor of it.
Well, then a quick question then. This would thereby terminate the Recreation Task Force, is that correct?
Yeah, it would probably come up as a subcommittee, or however they try to decide to reorganize it. That's up to them.
But as a separate organization?
It will not be a separate task
Okay.
force now.
Okay,
Yeah.
so that's just to keep the books clean.
Yeah.
Okay. Any further comments? Eric?
Question, so then would I anticipate at our next meeting having a new charter?
They are
Proposed?
going to work on it. As soon as they hear that this is acceptable, they will start to create or amend their charter, and will present it to the board at the appropriate time.
Further questions?
Right here.
Yes, Steph?
Will you be amending this to terminate the rec task force because you still have a chartered task force? So if you're going to do the consolidation,
We
Yeah.
do not have a charter task force.
Yeah, we do.
Yeah,
Not a
we
rec-
do. So my
It's not a charter.
I thought that's what we just said in the motion.
Yeah, that's my
That it would take
understanding, but
place.
why don't we go ahead? I think it's a valid point.
Shall I make a different motion then?
No, let's somebody make a motion that,
To amend it?
to amend this by addition of the comment that the rec task force is formally disbanded.
I would like to propose an amendment that we amend this motion to also disband the rec task force consecutively.
Second.
Okay, the amendment has been made and seconded. All in favor of the amendment, please indicate. That's unanimous. Okay, now we're back to the underlying, oh, David, do you have a vote?
Yes, I approve.
Okay, unanimous. Thank you, sir. Thank you, Eric. And now we're back to the underlying motion. Any further comment? Okay, then I'll entertain a motion to call the question.
Call the question.
Okay, question has been called. Unless there's any objection, all in favor, please indicate. That's unanimous here. David?
Approve.
Thank you. Unanimous. Okay, then the next is also on your plate, ma'am. Fee waiver request.
This is a little unusual. I understand that there is a group of homeowners here, members here in Sudden Valley, who are working to put together some kind of an event program for Sudden Valley members. They are trying to figure out if they have the means to do so, but they'd like to make it free to Sudden Valley members. So they discussed a little bit what the cost of, they would use the dance barn, and they would probably need it 2 to 3 4-hour sessions. So when they heard what the cost was going to be, it was a little more than they were anticipating, and they don't want to have to charge a fee, and they don't know if they can get enough donors. So the request is to ask if, being that this is a volunteer group, doing a presentation or an event for homeowners for free, could we as a board consider waiving the normal fee for the room? The idea would be they would not use it during any time that anyone has already booked it, so it would not remove anyone else's opportunity or our opportunity to gain income from it.
Would you make a motion, please? First, we need a motion.
Okay. I move that and I'll have to get more details about this group, but it would be in September or October, depending on what probably more like October because of our things, but for this group to be able to receive the use of the dance barn for 3 4-hour sessions for free.
Second.
Moved and seconded. Okay, now, is there any further discussion? You've kind of explained it, Sarah, and then Eric and Linda, too. I don't know who was first, but Sarah, definitely.
I am uncomfortable with this? Because we don't, I mean, you're saying you want to get more information on them. What are they going to be doing? I mean, this is very vague, very early. It seems kind of way early to be approving waiving fees when you don't even know what they're going to be doing. Just my opinion.
A play. It's a play,
But
yes.
Mr.
Okay.
President, Eric?
Yeah, thank you, sir.
That was, I felt that was a very valid question. Mine is, because we're talking about September, October, I wanted to have assurances that it wouldn't be a political slanted event. And so that would be my reservation.
So is that a question to the proponent?
I think that it sounds like this is still in the exploratory phase. Are we giving approval to continue exploring, or because
A play has been chosen, and the name escapes me. It's one that is copyrighted, and they will use a standard play, and it does not sound to me like it's anything that's political, but I certainly, if you wish me to bring more information, I can. It's just the idea that they want to present an opportunity to present a program as volunteers to the community to bring people together.
Okay. Linda, did you have?
So is this just, they're just going to have one performance? Three.
No, they're going to do one dress rehearsal and 2 performances, unless they have no one at the first performance, and then they may not do the second one.
I just, for the board, it's just, and I guess because with NNE, we have, there's town halls that may come up.
They would not conflict. They assured me they would work around whatever schedule we have for, because they understand the political thing. They really don't want to be part of that. They don't want to be part of the political portion.
Yeah, that's what I was saying.
Yeah.
I was also thinking
Yeah,
of the
yeah.
candidate forum, that sort of thing that's going
Correct.
to have to go
We've got
on
lots.
in that
We have the
timeframe.
measures, we have the town
Yep.
halls, we've got
Thank
the
you.
forums.
That's
Right.
all.
Okay. Yes, ma'am.
Sorry, follow-up question. My other concern would be, I don't know how they can guarantee it won't conflict from 1, revenue opportunities, or 2, things we may plan, because they would want to give some notice to the community it's happening, and you can only give so much notice without knowing someone else is going to reserve it. So that's kind of a difficult balance to keep.
Okay.
I'll only say that, that they will work with Mitch to ensure that it's not going to conflict with any of our scheduled events for that, or, for instance, weddings, or any other thing that might come along that would probably need a bit more lengthy type of notice.
That's all I have, sir. Oh,
Quick follow-up question. Would I then understand that what we are being presented right now is a motion that is to waive the fees of the dance barn rental to do something for the community, understanding that it would check off all of these concerns that we've raised tonight? Is that my understanding?
Yes.
Okay.
And the answer for those who didn't hear was yes.
we didn't ask David, sir.
David, do you have any questions?
No.
Okay.
That's all, sir.
Okay, given that that's all, can we go
Call the
to a vote?
question?
Question has been called. Without objection, then all in favor of this motion, please indicate. I got 1, 2, 3, 4. David, where are you at?
I approve.
Okay, 5 in favor, and all opposed, please indicate. 1 opposed. Okay, the motion does pass.
Mr. President, may I ask a question?
Yes, sir.
I'd like to make this a one-off. I would, just to clarify, I wouldn't see this as a standard by which we would make other agreements. I think an agreement like this must come to the board rather than us assign the space for free.
That is certainly the normal procedure, and that's why we're considering it as an individual motion.
Thank you.
This is not an amendment to the fee schedule whatsoever.
Just being very clear.
Thank you very much. Okay, so, with rather some surprise at the speed with which we've gone through the agenda tonight, We are now, we are now back to property owner comments and board response. So are there any further community comments? I don't, oh, yes, sir. Believe me, I feel your pain.
My name's Tom Henning, 27 Parr Lane. Over the last couple of weeks, I've seen a real lot of negative commentary on social networks about these people. I've been here 2.5 years. For the first 10 months, I was part of them. It's real easy to buy into that crap. But I chose to step out when it just got so outrageous. I couldn't believe it anymore. I stepped out and looked into it myself. These people are hard-working people. They deserve our respect. They don't get paid for what they do, and they take a lot of crap. So we need to shut this down. I don't agree with everything they do, but I damn sure respect them for what they do. And that's all I want to say.
Are there any further homeowner comments, please? Yes, sir.
My name is Bob Wolven. I live at Center Condos, number 29. This has been a good year for me. I got to raise my Social Security, $11. $11. And I voted strongly to give the $11 to Sudden Valley. I have a net gain of 40 cents is what I have.
Take it to Ken's Kitchen. Take it to Ken's Kitchen.
Yeah. I'm 74 as of yesterday. I have 4 grandkids that live here in the valley, and a son that's a paramedic with Bellingham Fire. He's also on the SWAT team. We're really embedded in this community. We love this place. It's probably our last home, I would imagine, that we're going to call home, this side of the grave. But I just want to really thank the board and Mitch and Lisa. I'm really not into these meetings. They're a pain in the butt. And the chairs are terrible. But I just want to say thank you, Mitch and Lisa, for what you guys do. There's so much goes on that we don't know about. We haven't got a clue what happens sometimes, what comes over the phone or over the CB or whatever. So this is an awesome place to live, and I'm sure glad I'm part of it. Thank you, Mitch.
There any further? I see 2 hands in the back. Oh, you guys are going to tag team.
Hannah Oliphant, Division 27, Lot 55. And I would like to say, kind of, agreeing with previous comments that, I too got caught up in the underworld of Facebook. And, up until the day of the AGM, when I had voted yes on both measures that had failed, it was sad. And I still had I don't want to use the word resentment, but I guess that would be close to what I could define it to. And I was, up talking to everybody, and Mitch came up. Even though I sat on Facebook talking crap, calling him names, this man still came up, shook my hand, and told me it was a pleasure to meet me. He knew me already. And that speaks a lot to his character. It does. Because at that point, I was probably one of the more vocal opposition. I'm sure a lot of you can agree, even though you won't shake your heads. But, It was humbling for me. And I want to thank him for giving me that opportunity to get to know him. And I have not been sorry since. And you guys are all doing an amazing job. You put in so many hours. I see it now. I see that Mitch is working hard to make this community better. If the proof is in the fact that we are collecting 97% of our dues now. In 1994, when I started reading the views from before, in 1994, there was a $380,000 deficit. So that, when somebody says, show me what they do, well, that they are making our community better. Thank you, Mitch, and thank all of you.
Hannah and I we try to make sure that the meetings get streamed everywhere under Eric's tutelage. And I'm Sharon Wash, amen, and I live at 25 Windward. And I have loved getting to know the people in this community. I've lived here since 2000, and that's 18 years, and if my math is right. And I like volunteering, and what I love the most is how all of the committees are trying to work together now. I just found out that the Emergency Preparedness Committee wants to work with the Communications Committee, and I just think this is just so great. I know people on Facebook, they call me like Kumbaya and Pollyanna, but I like my neighbors. I don't agree with everybody. I do agree with a lot of what's gone on, and yes, I vote for paying more dues when we need to, and I think I support Mitch because he is somebody who doesn't stare you down as much as intently try to listen to what you're saying. And I think he has my husband's hearing problem, so he tries to, I'm sorry, Mitch, he tries to look at faces to understand, or maybe I'm wrong, or maybe I shouldn't have said that. I'm sorry, Mitch. But anyways, what I need to say now, yeah, I'm sorry. But I did want all of us to just keep good thoughts for Summer Cronk's daughter, because she's us, and thoughts and or prayers, and I know what that's like. I have a grandson who nearly died, and unfortunately he's not recovered completely, but I know that feeling. I watched my daughter for 2 weeks never leave the hospital, and I know what Summer and her husband are going through, and I just think it's nice that we are all thinking or praying, whatever you do, to the universe or God. Okay, that's enough. Thank you.
Thank you, Sharon. Are there any other homeowner comments? Okay, are there any board comments?
Before we lose Kumbaya, I vote that we adjourn.
Second.
Okay, moved and second to adjourn at 8:08. I think that's a record.